Hi, my name is Greg Wagman. I'm an attorney in New London, Connecticut. I've been an attorney since 1992. And one of the areas I focus on is operating under the influence, driving under the influence, driving while intoxicated. The official statute name in Connecticut is operating under the influence of alcohol or drugs. I'm a solo practitioner. I focus on the DWIs, the OUIs, criminal defense, personal injury, and bankruptcy are my areas that I practice in. Who is this for? This is anybody that's been picked up for a DWI or an OUI in Connecticut. Rhode Island's different, Massachusetts different. Every state has nuances to their laws. Some of the overall broad things apply everywhere, like a .08 is everywhere because of federal highway funds are tied to every state having a .08 alcohol limit, .08 blood alcohol content. So in Connecticut, you have two different things that are going to go on. One is you're going to get a letter from the Department of Motor Vehicles, and then you're going to also get a court date from the arresting officer. The letter from the Department of Motor Vehicles affects your license and whether or not you're suspended in the state of Connecticut, and the court controls whether or not you actually go to jail or wind up with a conviction on your record for operating under the influence. Obviously, there's a lot of political pressure on these types of cases. Mothers Against Drunk Driving has made sure that they keep this in the forefront of the legislature's mind, and so these laws are changing all the time, and they are changing in the direction of getting stricter and stricter. First step: if you do get a DWI, you're going to get a letter from the Department of Motor Vehicles. Make sure you have the proper address. So you get the letter. You have 7 days from the date on the letter to respond and request a hearing with Department of Motor Vehicles. And so that includes mailing time. Department of Motor Vehicles only has to certify to the court that they actually sent the letter. They don't have to show that you got it. So one of the things to pay attention to is make sure if you get a letter from Department of Motor Vehicles, request a hearing immediately. If you don't request a hearing, you're not going to get a hearing. If you request a hearing, the worst the case happens is you lose, and so, but you're still protected any kind of rights you may have had to avoid a license suspension through the Department of Motor Vehicles. What are some of the questions that people ask me when they come in? I was drinking, so therefore I'm guilty. Maybe, maybe not. The state has to prove your guilt beyond a reasonable doubt. Now we're in court, not at the DMV. So if there are issues about how you got pulled over, there may be issues about how much you were drinking or what was going on in the circumstances, how long before you were actually stopped by the officer. So all those play into the fact of whether or not you're actually legally under the influence. If you walk into court and you don't have a lawyer, I can assure you the prosecutor's not going to tell you they don't have a case, because that's not how they think. So should you have a lawyer or should not have a lawyer? I mean, obviously that's up to you, but I'm in court on many DUIs each month, whereas this may be hopefully your first or maybe your second. So things that you may not think of or know about are things that I'm thinking about all the time. Sometimes we can help you keep your license. That's up to DMV, or court will suspend your license in addition to the DMV license if you get a conviction in court. You may not get a conviction in court. Sometimes we can avoid jail, sometimes we can't avoid jail, depending on how many DUIs you have in your past. In Connecticut, if you have a first DUI or OUI, and you take what's called alcohol education program, you complete that program, and it's been more than 10 years since you've completed that program, then you might be able to eligible for the program again. This assumes that this is just a straight up DUI without any other aggravating factors. if you're within the 10 years, it's now a second offense, which is going to wind up being a first conviction. Now you have a conviction on your record. That first conviction will be a misdemeanor. Second conviction becomes a felony. So if you have a job where you aren't allowed to have felonies, that becomes a huge issue. If you had an accident, somebody else got hurt during your operating under the influence, that makes the level of, or that makes the attention that a prosecutor pays to the case a lot greater. Somebody else got hurt. Now you got issues. Now you got much bigger issues. But if you hire an attorney, there's a lot of things we can do to mitigate the consequences of what's going to happen to you. Most get resolved prior to trial. Most cases plea out. The prosecutors here know that I will try a case. I have tried DUI cases before. I will try them if I think we have facts that are going to help my client win. There are unusual situations where other things like mouthwash, or sometimes some people's bodies create what's an alcohol in their stomach, and they can blow above the 0.08 on these breathalyzer, and if that happens, it's we have to get medical evidence to show that kind of stuff. Sometimes we can do a motion to suppress if the officer didn't properly pull you over. More favorable sentencing. That's in every case we do. We try to negotiate the most favorable sentence we can possibly get. We keep up on the appellate decisions, what's going on in court, not only in the appellate courts, but also at the legislatures, to know exactly what's going on with these types of cases. And how to try a case and how to present the case to the jury is just as important as knowing the facts and the law. And as I tell all my clients, knowing what not to say is just as important as knowing what to say. At the first appearance of court arraignment, the judge might set a bond. Probably not if the officers didn't set a bond. If the officers didn't hold you, gave you a promise to appear or a non-surety bond, you just have to make sure you show up in court at the first arraignment for dates, which used to be within 2 weeks of your arrest date, which is now they'll still set it within 2 weeks, and then the court will probably continue it at this point. But the first court appearance is just to get the process started. They have to get discovery to your lawyer or to yourself. Discovery is copies of the police reports. You're not going to be given a copy of the police report at the time of your arrest. It just starts the whole process. Don't be late, obviously. Never interrupt a judge, ever. You can challenge the judge politely, and certainly ask the judge for answers to certain things. But interrupting a judge is just never a good deal. Are there alternatives to jail? Yes. Sometimes I've had clients go to inpatient rehab, and that's depending on the judge, depending on the situation. We can have the treatment program substitute for jail time. That does happen. Other things we do is get the treatment in ahead of time, and then the person can go to. Then if the person has mandatory jail time, sometimes the Department of Corrections will take that into consideration when releasing the person to home confinement, and so you can be released earlier. A third DUI, a third conviction in Connecticut is a 1-year minimum mandatory jail time. So the Department of Corrections has to hold you, whether it be in jail or at your house. They can do home confinement, but if you have things set up right and you've done things ahead of time, you may be able to reduce the amount of time you're actually in jail. Is there any way to avoid losing your license? Maybe, maybe not. It really depends on the situation you're in. And remember, you got two things going on. You got DMV and court. You can win at DMV and lose at court, and vice versa. They have no effect on each other. If you lose at DMV, or you don't fight it at all, if you're between 18, if you're anything under 21, it's 0.02 is the limit for drinking for under 21, which is basically nothing. If you refuse to blow, you're going to get a 1-year suspension from DMV. If you blow and blow above a 0.08, you're going to wind up with a 6 months. Excuse me, it's not a 6 months with the IID in your vehicle, a 45-day hard suspension, and then 6 months with an IID in your vehicle, or a 45-day suspension and then 1 year with an IID, a breathalyzer in your vehicle. One of the key things for this is, in that 45 days, you might be eligible for a work permit or a school permit. And so you might be able to drive to and from work. So that's very important, obviously, for many people. But if you don't have a work permit, or you're driving outside the hours that they give you for your work permit, it's called operating under suspension, alcohol related. The least the judge is allowed to give you is 30 days in jail, if he likes you. If he doesn't like you, he or she doesn't like you, give you up to a year in jail. So it's really important not to drive under an alcohol-related suspension. And they don't have to show that you even knew about the suspension. All they have to show is that DMV sent you that letter. Doesn't matter whether you received it or not, and that you were driving. And so it's a very, very difficult situation to defend. I have gotten people off of those, but it's really hard. So it's just not worth playing with. The second caveat to all this stuff is, if you're driving a vehicle that doesn't have a breathalyzer, same deal, 30 days in jail if the judge likes you. If the judge doesn't like you, up to a year in jail. So it's very, very important to pay attention to that. I've had people just literally driving from his sister's house to the bank to go to the ATM, got caught at the bank, 30 days in jail. Very difficult to undo. Special circumstances, high blood alcohol level, sometimes you see these people at 0.1s, 0.2s. Judges will and prosecutors will increase the penalties for some people in that situation. If you have a CDL, you are not eligible for a program. You cannot go to court and ask for even if you have a CDL and you're not in a commercial vehicle, you're in your personally owned vehicle, and you get caught driving under the influence of alcohol, you do not have an option of taking some classes and getting the case dismissed, even if it's your first ever, and you will lose your CDL for a year. So it's super important for anybody that is making a living driving commercial vehicles. You do not get options that other people without a CDL get. Anytime a motor vehicle accident, somebody got hurt, because whether it's your own passenger or whether it's somebody in another vehicle or a pedestrian, major issues. That's that you've increased the difficulty of your case by a lot. Multiple offenses. First one in Connecticut, as long as you don't have any aggravating factors, you're going to be able to get away with get everything done and completed. You're not getting away with anything because there's a lot of hoops to jump through. But if you jump through all the hoops properly, at the end of that, you're going to get your case dismissed. If you took it to trial and won, you're going to get a dismissal. In other words, it's the best result you can get is a dismissal. So if you jump through all the hoops and get everything done, you can on a first offense in Connecticut, you can wind up with a dismissal. If you pick up another one within that 10-year period, you're going to wind up with a first conviction, a second offense, a first conviction. First conviction is 48 hours in jail or 100 hours community service, somewhere around $900 in fees, fines, and costs. Loss of license, again, the insurance is going to go through the roof in all of these things. Third offense, second conviction in Connecticut, it's 120 days in jail. Fourth offense, third conviction is a year in jail. Minimum mandatory, it's the least the judge is allowed to give you. And you start winding up with felony convictions on multiple offenses. So that answers your first question there. It's a misdemeanor. The first one's first conviction. Your second offense is a misdemeanor. After that, it becomes a felony. Get your case thrown out because the cop didn't read your Miranda rights? Not likely. What we can do, if the officer has you in custody and you give a statement and they haven't given you rights, then maybe we can get the statement thrown out. Again, it's going to be your word against the officer's word, and they're going to say you were drunk and the officer wasn't. So you figure out how that's going to play out. Most people that get a DUI or OUI are not alcoholics, and most people don't have to go to AA meetings. AA meetings are voluntary. Does it help you sometimes in certain situations? Absolutely. Do I recommend it sometimes? Yes. But is it going to be part of your sentence? Probably not. It may be if you're on probation, if you get put on probation for one of these things, but that, again, you're at least on your second offense at that point. Implied consent. If you have a license in the state of Connecticut, you have given consent for them to take a breath or blood test or a urine test to check for drugs or alcohol. And if you don't, you've already given your consent when you get your license. So if you don't comply with any of those tests, the penalties are greater. Can you get accelerated rehabilitation for an OUI or DUI? No. It's specifically limited. Accelerated rehabilitation specifically says you can't get it for an OUI or a DUI. You may be able to get what's called the alcohol education program, which, again, if you jump through all those hoops, you may be able to get through all of this in Connecticut for your first offense without a conviction. What happens? You get caught driving while your license is suspended. We're back to that 30 days in jail. Driving without an IID when you're supposed to have one, 30 days in jail. You might be able to get a work permit, driving to and from work, and and doing some basic, very quick errands within certain times. But again, if you're outside of those times, 30 days in jail. Do you have to tell your insurance company? You don't have to tell your insurance company. DMV is going to tell your insurance company. They're going to find out. You're going to wind up having to pay more for insurance. Prescription medications, doesn't matter. In fact, I tried that case and it went up on appeal, lost at trial, lost on appeal. My client was taking prescription medications, and I had the doctor that prescribed them come into court and say, yep, those are his meds, and those are the levels that he's supposed to be at. Did not help him. So if you're under the influence and the officer thinks you're under the influence, it's going to be a difficult case. Fees and costs and these things can add up quickly because every time you turn around, they're hitting you for something, and it rapidly gets expensive. So sometimes, and we try to as much as possible, is reduce or the fees and the costs for every client in any situation. Actually, don't wait too long. Don't come into me a month before trial. Judge says you're going on the trial list. You're going to trial. It's too late to gather any kind of outside evidence. It's too late to really put a good case together. the best time to come and see me is right after you got the DUI. It's because then it's because then we can figure out what the best direction is going to be for you, and make sure we start heading in that direction early. And it's a free consultation. Come on in and see us. I'll tell you exactly what I think about your case, what I think about your situation, and we'll go from there. And if you want to hire us, great. If you don't, that's fine too. But come in and see me or another attorney if you get one of these things, because and go for an attorney that does these types of cases. You want somebody that's got experience and has been to seminars. I've been to a wide variety of seminars on this particular topic. In fact, I'm actually been certified to give the breathalyzer tests and not the breathalyzer, but the field sobriety test, the walk and turn and the one-legged stand and that sort of stuff. I've taken the class. I'm taking the same class that officers take to decide whether or not you should be arrested for operating under the influence. And so this is just for informational purposes. If you really want to know about your particular situation, come on in and see us, and we will figure out what the best direction is for you in your own particular situation. One of the other complicating factors, actually, which I should have mentioned earlier, there's now a special statute. If you have children under the age of 18 in your vehicle and you get arrested for operating under the influence, there's an enhancement now. Now things again get harder. So those are the types of things that we're looking for to help you get through. So if you have any questions, give us a call, 444-0100. Call us, text us, and we can help you go from there.